All right, people. So welcome back to our lecture series on current affairs. Now, today we are going to cover Indian polity related current affairs from the past 1 week. If you have been following this lecture series, you know this, that we cover current affairs subject-wise. That way, it will be easier for you to integrate your current affairs with your static portion. Now, needless to say this, but still I'm going to say it, you have to make this lecture series a part of your daily routine. Because if you make it a part of your daily routine, well, you'll not only integrate your static and current affairs, you'll also ace your current affairs, okay? At least in your exams. So make it a part of your daily routine. You just have to spend 45 minutes of your day. That's about it. 30 minutes of watching the lecture and 15 minutes of it revising the lecture from the notes. Just 45 minutes, and that would be all. This consistent habit will serve you really well. Follow this habit till your exams. All right then. Enough of the introduction. Let's straight away dive into the lecture. But first, let's take a look at the topics that we shall cover in today's lecture. So let's begin. So current affairs, Indian polity, June part 5. As you know, we cover weekly current affairs. So polity related news items from the past 1 week shall be covered in today's lecture. And today we just have to focus on 3 topics. Okay. Recently, there was this judgment or opinion given by the Supreme Court with respect to whether right to vote is a fundamental right or not. There has been considerable debate regarding this. Is right to vote a fundamental right or not? Okay, so we'll talk about this. Actually, it's not, but I'll clarify this. Then topic number 2 is related to court permissions for further investigations. This is related to our criminal code. Okay, criminal code or criminal procedure code, or today as we know it, Bharatiya Nyaya Sanhita. All right, so these questions related to police investigations are also now being asked in your prelims examination. Therefore, we need to cover it. And the last topic is related to criminalization of politics. This is more important from the perspective of mains examination. Nonetheless, it is very important. In fact, this topic is important for every citizen to know about, okay? Not just UPSC aspirants. But as UPSC aspirants, we need to have a good knowledge about this topic. We need to know it thoroughly. So these are the 3 news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is right to vote as a fundamental right. Now, generally people confuse this thing, okay? They think that right to vote is a fundamental right, but actually it's not a fundamental right. It is mentioned in the Constitution, but not in the chapter of fundamental rights. It's mentioned in Article 326, basically saying that every citizen in India has a right to vote above the age of 18. So universal adult franchise, this is construed as right to vote. But it is written in Article 326. So it is not a fundamental right. At best, you can call it a constitutional right. But the workings of this right to vote basically are given in Representation of People's Act 1950 and 51. So some people say that it is not even a constitutional right. It is actually a statutory right, legal right, ordinary legal right. Now, what is the reality? Whether it's a constitutional right, whether it's a fundamental right, or it is an ordinary legal right, statutory right. Let's investigate this entire matter, and let's also talk about the previous Supreme Court judgments, which have given some opinion on this matter. All right, so let's begin. So right to vote as a fundamental right. Now, as UPSC aspirants, you should know this. It is not a fundamental right because it is nowhere mentioned in Chapter 3 of your Constitution, or let's say Part 3 of your Constitution, which is a chapter on fundamental rights. Okay. In a landmark ruling delivered on April 11th, the Supreme Court of India settled contemporary ambiguities by explicitly reaffirming that right to vote and right to contest elections are fundamentally statutory rights, not absolute fundamental rights under Part 3 of the Constitution. Okay. And what are statutory rights? Rights that are a result of law made by Parliament or legislature. Now, Parliament has made a law on this, and these laws are Representation of People's Act 1950 and 51. But some people say that you shouldn't just call it an ordinary legal right. It is a constitutional right because it is mentioned in Article 326. So what is the reality? Okay. So the constitutional architecture is like this, multi-tiered constitutional and statutory architecture. The root of right to vote comes from Article 326, which says that every citizen in India, irrespective of caste, creed, color, cult, anything, okay, religion, well, has the right to vote. Now, with every citizen, well, initially in the earlier version of the Constitution, it was everyone above the age of 21. Later, This provision was amended through a constitutional amendment, 61st, 1988, and the age was reduced to 18. So everyone above the age of 18 has a right to vote, okay, with reasonable restrictions, and Parliament has the right to give those restrictions, okay. Not everybody above the age of 18 can vote. There are certain restrictions, like people who are serving prison sentence, they cannot vote, okay, but those restrictions shall be given by Parliament, okay. But the foundation is laid in Article 326. Now, Parliament enacted two laws with respect to this. Representation of Peoples Act 1950, which talks about electoral rolls, voter list, and Representation of Peoples Act 1951, which talks about conduct of elections, how elections would be conducted by Election Commission of India. In fact, the 1951 law has a particular section called Section 62, which talks about voter qualifications. Like, for example, Section 62, Clause 5 states that anyone residing in a prison or serving a prison sentence loses their right to vote unless they are released from prison. Okay, so this is mentioned in Section 62. So basically, the foundation or the root comes from Constitution of India, but the workings of right to vote, well, they are basically through these statutes. Okay, but in certain Supreme Court judgments of the past, well, right to vote was construed in a way, we'll talk about which way, as part of Article 19, Clause 1, Subclause A, which is a fundamental right to free speech. Okay, some Supreme Court judges have construed right to vote as part of your free speech and expression, because saying that basically they opined that if you are, your right to vote is also your way of expressing who should rule you. So that expression cannot be curtailed. Hence, in a way, in certain judgments, Supreme Court has somehow construed right to vote as part of Article 19, Clause 1, Subclause A. But that was only in some way. If you ask this very pertinent and very fixed question, whether right to vote is a fundamental right, constitutional right, or statutory right, the answer would be ordinary statutory right, legal right. That should be your answer, whether it's prelims or mains. Okay, various judges have construed it in a different way, but this is the final equation. Make sense? Now, what have previous Supreme Court judgments said about this issue? Okay, so there are 4 judgments that you should know about. Number 1, N.P. Ponuswamy versus Returning Officer of the Election Commission. This was the classical view. The classical view is right to vote is an ordinary statutory right or legal right. This was reaffirmed in this another judgment called Jyoti Basu versus Devi Ghoshal, 1982. But then, certain Supreme Court judges basically gave a differing opinion. The first time it was expressed was PUCL case in 2003. PUCL stands for People's Union of Civil Liberties. This is an organization, NGO, which filed a case in Supreme Court. So in this case, well, one judge opined that, look, right to vote is crucial for democracy, and democracy is part of basic structure of the Constitution. So it would be a little light-handed if you say that it is just right to vote is just an ordinary legal right. At least say this, that right to vote is a constitutional right. The judge agreed that it's not a fundamental right, but he said that we should consider it constitutional right as guaranteed under Article 326. But the thing is that this opinion was that of a particular judge, not the entire bench. Okay, this was there. And then in the second PUCL case of 2013, well, the Supreme Court or certain judges of Supreme Court also said that it's not just part of Article 326. It should also be construed to be part of fundamental rights under Article 19, Clause 1, Subclause A, which is free speech and expression. Again, this opinion was given by some judges, not the entire bench. So it's not the official version of Supreme Court, yet Supreme Court has somehow, when it suits them, construes right to vote as fundamental right also, constitutional right also. But you should remember this. The official position is this only, the classical view. Okay? Now, if tomorrow a larger bench of Supreme Court sits, okay, in certain case, in a different case, and gives this judgment that no right to vote is a constitutional right or a fundamental right. Then what will change? Well, this table gives a proper comparison. Okay, column 1 is if it is treated as purely legal right, present model. If tomorrow Supreme Court in a different case elevates it to fundamental right, then what will happen? So, sovereignty of Parliament. Currently, Parliament retains full legislative power to impose restrictions on your voting rights because it's a legal right, so Parliament can amend it anytime. But if it becomes fundamental right, then Parliament cannot restrict your right to vote or make changes to that without being challenged in the Supreme Court. So this is there. If somehow Parliament violates your right to vote, well, you can't go anywhere today. But if tomorrow it is treated as fundamental right, then you can directly go to the Supreme Court under Article 32, because Article 32 clearly says that if your fundamental right is violated or restricted, you can file a challenge to that government action in the Supreme Court directly. So you can directly go to the Supreme Court. Currently, you can't. And then electoral integrity. It allows the state to quickly build administrative safeguards requiring physical voter IDs, strict residency parameters. Disadvantaged or migrant groups could challenge strict domestic residency rules as direct violations. So this is an example, like recently SIR exercise was conducted, right? And it was challenged in the Supreme Court. Bihar SIR, Bengal SIR. But if right to vote is a fundamental right, any citizen can challenge SIR directly in the Supreme Court under Article 32. So this ties the hands of Election Commission of India to conduct elections, because every time they'll take action, someone would challenge their action, because right to vote is a fundamental right now. That is why, to grant some flexibility to Election Commission of India, that is why Supreme Court treats it as an ordinary legal right. Otherwise, it will become really difficult for Election Commission to conduct elections, because every step of the way, someone would challenge their order. Okay, but what should be the way forward? We can't just call it ordinary legal right. After all, right to vote is the bedrock of democracy in India. So we should follow a constitution plus framework. Okay, this means that ordinary legislative laws cannot change or abridge your fundamental right. Okay, we need to find a way out, middle path. Then reform section 62 clause 5, because under this, anyone serving a jail term or inside jail cannot vote. But there are many under trials in jails. I mean, there are allegations. Under trials are those people who are not found guilty. The cases are currently going on, but for time being, they are put in jail. But the charges against them are not proven yet. So why shouldn't they be allowed to vote? You need to amend this. Plus, use technology to provide voting rights to everyone. Okay, because of certain problems, certain people do not get full access to right to vote because there are some migrant people and many other problems are there, right? So use technology to solve this crisis. This is the way forward, and that's about it. All right, now let's quickly shift our focus to second news item, and that is court permission for further investigation. Now, this is a very small topic, okay? The thing is, like generally, UPSC used to focus more on constitution and certain important laws. But these days, UPSC is also focusing on criminal investigations and, legal structure surrounding criminal cases. These things are also being asked these days in UPSC prelims examination especially. Therefore, we need to take a good look at this news item. Now, what is this news item all about? Well, let's suppose the police catches a suspect in a criminal case, okay? The police files a charge sheet in the court. So what happens is that if there is an FIR, the police conducts an investigation, okay, finds the criminal, okay, holds them in police custody and then produce them in the court. When the trial is going on in the court, the police has to file a charge sheet, okay, framing all the charges against that person, okay, that accused. After that charge sheet is filed, the trial goes on based on that charge sheet. Now, sometimes the police feels that some new material, new evidence has come out in the open and we need to conduct further investigation to probe those charges. Now, can the police, after filing a case in the court and after filing the charge sheet, continue with their investigation and file supplementary charge sheet or produce new evidence? Can they do that? Well, the Supreme Court has recently said they cannot on their own. If they want to continue their investigation even after filing a charge sheet. Though by law, their investigation should be complete before the charge sheet phase. But if they want to continue supplementary investigation, supplementary report, if they want to do that, they have to take the permission of the court or the magistrate. This has been made clear by the Supreme Court recently. Now, well, criminal cases were governed by Criminal Procedure Code in India. Okay, that was the law. That law was silent on these supplementary investigations, whether police can conduct them or not. But this Criminal Procedure Code was recently replaced by a new law called Bharatiya Nyaya Sanhita. In that, the parliament has made it clear that no, you cannot conduct fresh investigation. You need to take the permission of the court, and the Supreme Court has made it doubly clear. You understand the entire issue. After filing a charge sheet, can you continue with new investigation or further investigation? Okay, so let's quickly discuss this. It's a very short topic. In a landmark case, Paliswamy V. Raja versus State of Karnataka, the Supreme Court delivered an essential clarification harmonizing legacy practices with newly implemented laws. Earlier, the law, Criminal Procedure Code, was silent. But this silence was done away with, categorically mentioning that you need the permission of the court to conduct further investigation in Bharatiya Nagrik Suraksha Sanhita. Sorry, not Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita. So, first of all, you need to be aware of certain core concepts. Okay, there are two terms. After filing a charge sheet, there are two things that you can do, police can do. One is further investigation. Additional supplemental continuous inquiry designed to gather fresh evidence relating to same crime. It does not wipe out the previous investigation but builds upon it. The next is fresh investigation, re-investigation de novo. De novo means the police realizes that their previous investigation was not correct. We need to cancel the previous investigation and conduct new investigation from afresh. So this previous charge sheet also, well, doesn't mean anything. This is what a fresh investigation is. Fresh investigation is completely prohibited. This is the prerogative of the court. Only if the court orders that you need to conduct fresh investigation because they feel there is miscarriage of justice, only then police can go for fresh investigation. Police cannot do it. And when it comes to further investigation, police can go for further investigation. They just need the permission of the magistrate. Okay, this is the clarity that, well, police needs to have. Criminal investigative agencies need to have. Okay, now judicial precedents, the judiciary has made this clear in previous judgments also, like Vinay Tyagi versus Irshad Ali, Rama Chaudhary, Paliswamy V. Raja is the latest one. Okay, now this is what the older criminal law was, CRPC, and the new BNSS says. BNSS has basically plugged those loopholes with respect to this issue in the previous law. Okay. Now, in fact, in BNSS, if you need to conduct fresh further investigation, there is a 90-day limit only, strict time limit. There are various other safeguards so that police doesn't misuse its powers. Okay, because earlier what police used to do was, if they want to keep someone in jail, well, they would just give this excuse to the court that we are continuing our investigation, we are further investigating, we need another date and whatnot. That cannot be done. There is max to max 90-day limit, right? What is the significance of this? Well, through this, Supreme Court upholds right to fair trial because police won't be able to misuse its power of continuing investigation and keeping an under trial in jail. Okay, preventing administrative overreach, again, police overreach. Doctrine of implied and supervisory powers. The courts or the judicial magistrate has supervisory powers over the police. This was reiterated through this judgment. Okay, and ensuring evidentiary integrity. Once you have found the evidence, submit that evidence. You cannot change it, get out in the field and change it. No, you can't do anything. Whatever evidence you have collected should be filed in the charge sheet and then it is sealed. We don't want a situation like this that a new officer comes and tries to change the charge sheet. No, nothing of that sort. So this is the thing. Clear? Remember Article 21, right to life and personal liberty. Right to fair trial is part of your right to life. So right to fair trial is part of your fundamental rights. Remember this part. Clear? Make sense? And now let's move on to a very contentious issue which you all are familiar with, and that is criminalization of politics. So there is this NGO in India called Association of Democratic Reforms. Okay, they conducted a survey, or basically conducted a study, and they found that many Rajya Sabha MPs, not Lok Sabha, even Rajya Sabha MPs have serious criminal charges against them. This begs the question whether criminals are entering politics. And if criminals are entering politics, well, politicians have total control over everything, the state apparatus. If criminals are going to take control of state apparatus, well, that would be really bad situation for India, right? So we need to fight against criminalization of politics tooth and nail. So this Association of Democratic Reforms basically gave out certain statistics with respect to how many politicians have criminal cases against them. And then they gave certain recommendations way forward. Now, within this topic, we'll also talk about how judiciary has tried to stop criminalization of politics because Parliament has not taken many steps to stop this. So judiciary had to intervene. How did the judges intervene? We'll talk about that as well. So let's begin. So criminalization of politics, okay? So Association of Democratic Reforms analyzing the self-sworn affidavits of sitting Rajya Sabha MPs reveal that despite robust disclosure laws, money and muscle power continue to show structural resilience in the upper house selection pools. It's not just lower house. Even the Rajya Sabha is not free from politicians having criminal cases. Okay, what did they say? How did they measure this? The analysis revealed that 31% of sitting Rajya Sabha MPs have declared criminal cases against themselves in their own official election affidavits. You know, when someone has to fight an election, they have to file their nomination. Along with their nomination, they have to file an affidavit disclosing how many criminal cases are pending against them, disclosing what is their wealth, okay, how many financial assets they have. They have to disclose all this information. And that was also mandated by the courts. Earlier, they did not have to disclose anything. Okay, even if they have criminal cases, they would hide that. But now, after a Supreme Court order, it is mandatory for all politicians fighting elections to disclose their criminal antecedents in an affidavit. Using that information, well, ADR came up with this analysis. Plus, they said, out of the total legislative pool, 16%, so 31% have criminal cases, 16% had serious criminal cases like murder, kidnapping, corruption, crimes against women. Okay, serious. This is really bad news. Okay, now, criminalization of politics, what is the reason behind this phenomenon? Okay, core drivers behind criminalization of politics. So there are three major reasons why more and more politicians have criminal cases against them. Number one is winnability paradox. Political parties distribute tickets to local strongmen. These local strongmen have criminal cases against them, yet the political parties, all political parties are guilty of this. They give tickets to these criminals. Why? Because they are winnable. They win elections. And political parties have only one incentive: to win elections, come to power. Okay? They don't have this incentive of cleaning the politics of India. They don't want that. I mean, they do want that, but that is not their priority number one. Their priority number one is win at all costs. And if there is a criminal who is sure shot, I mean, who will win this election sure shot, they will distribute or they will give that ticket to them. So this is the winnability paradox, because every organization works on incentive, and the incentive for political parties is election victories. So they go for these criminals. Then asymmetric campaign self-funding. You see, fighting elections is costly. You need financial power. Sometimes black money based financial power. You need muscle power as well. Okay. Now, sometimes political parties are short of funds. They want those candidates who can finance their elections on their own, who can finance the muscle on their own. And these local strongmen, or as they say in North India, Bahubalis, well, they have muscle power, financial power, they can finance their own elections. So this is the reason. Plus, the third reason is the failure of our judicial system, because criminal cases take time. Sometimes Well, these criminals know how to delay the judgment. They know about delaying tactics. So a normal criminal case can take up to 15 years. Till that time, they can fight multiple elections and, well, go on with their business. So these are the three core issues. Now, the parliament has not been proactive in stopping this phenomena. Okay, so judiciary had to step in. And there are 4 Supreme Court judgments that somehow reduce this criminalization of politics. Otherwise, it would have been massive. What are those 4 judgments? You need to know about this. Okay. Number 1 is Association for Democratic Reforms versus Union of India in 2002. In this case, the Supreme Court made it mandatory for all politicians to file affidavits in which they disclose criminal cases against them, in which they disclose not just criminal cases, their financial assets. You need to disclose everything. How much wealth you have, how many criminal cases are there. You have to disclose everything. Okay? This is, well, part of people's right to know, right to information. Okay? So file everything. This was made clear. Then in Lily Thomas versus Union of India, this was a landmark judgment. Well, there is this section 8, clause 4 of Representation of People's Act 1951. Okay. You see, if you are convicted of an offense and the punishment for you is more than 2 years of jail term, you are disqualified from fighting elections for at least 6 years. But Section 8, Clause 4 said that if you have been convicted by a lower court and if you file an appeal in higher court, well, that means you are not, you haven't been proven guilty. You understand? So if you file an appeal, that means the case is still going on. So you got saved through this. In Lily Thomas case, Section 8, Clause 4 was struck down. If you have been convicted by a lower court, even if you file an appeal in High Court or Supreme Court, well, we don't know what High Court will say. But till that time, you are disqualified. This was made in Lily Thomas case. Then in Public Interest Foundation versus Union of India, it was made mandatory for all political parties to publish all their candidates or the criminal cases pending against all their candidates on their official website and their social media pages. This was made clear in Ram Babu Singh versus Thakur case, Ram Babu Singh Thakur case also. In this, it was said that if any political party doesn't do that, okay, what was said in 2018, if they don't do that, we will hold you accountable for contempt of court. So, well, judiciary has stepped in. There are still some loopholes in our laws. Okay, there are still some problems in our laws. These are given in this table, so do take a look. Though the judiciary has solved a lot of problems, but criminalization still exists. So that means there are still some problems. Okay, so do take a look at this table. What are those problems in our existing laws, legal framework, and what is the way forward suggested by Association for Democratic Reforms? Okay, very easy to understand. It is given in your notes. Just go through that. Very easy to understand. Okay, very relevant for your mains answers as well. Clear? And that would be all. With that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. I'm just sure about it. But it will add more value if you're number 1, consistent and regular with this lecture series. And number 2, you revise this lecture from the notes provided by us. The notes are shared on our Telegram channel, and the link to our Telegram channel is provided in the comment section just below this video. So do this necessary revision. On that note, I shall take your leave with the promise of seeing you again with another set of news items. Thank you, everyone.